Hi, let's talk about a topic that is mostly associated with lawyers, and that is notary or notarization. And usually pag sinasabing lawyers, panotaryo ka. No? So in this video, we're gonna talk about the law and the jurisprudence or cases in relation to the notarial law of the Philippines. As of the moment of this recording, the good law, the effective law, applicable law is AM number 02-08-13-SC. So let's start. So as we begin, what is a notary public? Tandaan, a notary public is a human being or a person. It is a public officer. So from the word public, it's not a private entity, it's not a private person, but it's a person of the government. Okay, specifically under the judiciary branch. So it's under the supervision and under the disciplinary supervision of the Supreme Court. All right, and his duty is to attest or to certify to the genuineness of any deed or writing. So let's remember that the word notary came from the word notarius or nota. So nota and then notarius, and then it evolved into the English name that we have today, which is notary, and it also is synonymous with the word clerk or secretary. All right, so as a notary, as a secretary, he notes that these documents are genuine. Okay, he puts a mark. Okay, he puts a note. That's why associated with the notarization is the seal. So pag may notarization, may seal talaga yan to certify the genuineness of any writing. Importante rin kasing genuineness kasi there's in this world it is rampant. There is a proliferation of falsified documents or falsehood. So in order to purify, to sanctify, okay, the pleadings and the documents and the agreements that revolve around us, we need truthfulness. So these public officers act as a filter, as a cleanser from the world that is drowned in so-called falsehood, no? In order to render them available as evidence of facts therein contained. So once it is notarized, it transforms, right? It transforms a private into a public document, except sa wills, and it elevates, next level na ang document na yan pag notarize yan. Hindi basta-basta dapat i-notarize ang isang papel because it will undergo certain procedures through a notary public. So they act like a sanctifier of frivolous and falsehood around us. So their hand and official seal give authenticity to certain classes of documents. So again, the word is genuineness or authenticity. Authentic, legit. No? Pinapa-legit, basta may tatak, may legit, may genuineness. His duties are sacred and are dictated by public policy and impressed with public interest. Bakit sacred siya? Because with notarization comes the faith of human beings. The faith of the public depends that once it's notarized, once, for example, a deed that transfers a property from one person to another, then that certifies that is genuinely executed, that the real owner himself made it with his own volition, not by force, not with vices of defect, but it is made voluntarily. All right. What is the purpose of notarization? Okay, from the word again, nota or mark or sign or seal of genuineness or trustworthiness. So once it's notarized, the trustworthiness of that document is leveled up. It is entitled to full faith, and it is a physical mark of a spiritual reality. So the spiritual reality, in a sense, that it is authentic and genuine. It is signed, okay? It is signed, or the notary witnessed the signing of the document and verify the identity of the party. So paano mo malalaman ang isang document ay genuine? Because it is signed by the real and authorized parties, and those parties were verified. Okay, na sila talaga yon, hindi sila doble cara, hindi sila hindi sila bogus, but they are the real persons behind that execution. So that's a spiritual reality. And what's the physical mark? The physical mark is the notarization, the attestation of the notary public that is genuine, authentic, and trustworthy. So there's a spiritual truth as well that is related to that, which we can associate. Katulad din sa life, no? Ephesians 1:13, and you also were included in Christ when you heard the gospel of your salvation. When you believed, you were marked in Him with a seal, the promised Holy Spirit. So same din sa spiritual reality. If a person is with God, he has a mark in himself, and that is the mark of the Holy Spirit, which is like a sign of ownership of your person by the Creator. So that's as well with the notarization. That is a sign of genuineness, authenticity, and truthfulness. So let's go to persons involved in notarization. So kanina, the notary public, that's the person. The other one is the petitioner. He is the person who applies for a notarial commission. He or she. So dito, pag nag-apply pa lang, that's a petitioner. And then once that application, that person that applies has already appeared and signed, then we can change the term into the principal. So pag nakita mo na yung pangalan niya in the document, then that person who appears before the notary public, whose act is the subject of notarization, is called the principal. All right? Petitioner, he comes to apply, and then principal, he comes and has already appeared and signed. So the persons who signed must be the very persons who personally appeared. So ang keyword din, to guard and to certify that is authentic and real, then the person who signed must be the person who personally appeared before the notary public. That's Villarin versus Sibate. Can a lower court judge notarize documents? The answer is yes. Under a circular of the Supreme Court na nandito rin, they can perform functions of notaries public ex officio provided they are connected with the exercise of their official functions and duties. Otherwise, it is unauthorized notarization. So yes, the lower court or the MTC judges can notarize documents only with two conditions. First, I think three, no? First, it has to be that it is related to their functions and duties, such as, for example, the filing of a pleading, okay? And then there's, for example, the certificate against forum shopping that needs to be notarized. And since, for example, the third condition is certification that there's no lawyer or notary public in such municipality, then that judge can notarize, no? And then ang problema kasi in some municipalities which has been judicially noticed by the court na may mga places, I don't know lang ngayon may mga places na walang notary public. So the judge themselves. So nakakaano nga, no? It's kind of weird that there could be places that there is a judge but there is no notary public. Well, that could be a reality, maybe absent, maybe nagkasakit. But again, that judge can certify or can notarize so long that is connected with the duties that or functions that he is performing, such as, for example, it is a pleading of, let's say, small claims case, all right? So he can notarize the certificate against forum shopping. And second condition is that the fees must not go to the pockets of that judge, but must go to the government, on account of the government. And third one, again, as stated, it must be certified that the town lacks the lawyer or notary public, as the case may be. All right? So, yes, and with these three conditions. So, first condition, lagay natin ng red. First, second, and third conditions. All right? So, yes, that this is in the case of Simon versus Aragon. So, what is the nature of a notary public's work? Okay, his duties are dictated again by public policy and impressed with public interest. They are sanctified, they are sacred, and as a member of the legal profession, he is required to obey laws of the land at all times and must exercise due diligence. His argument that was confronted with an alleged urgent situation is no excuse at all. So may mga arguments kasi na iba na ni-notarize nila without the personal appearance of the affiant, okay, of the person that is the principal. But then the court said it is not an excuse. The urgency of your situation is not an excuse. And then it is not a routinary act. The Supreme Court has always repeated this. It is not a pointless act or a routinary act, but it is invested with substantive public interest. Hence, only those qualified may act as notaries public. It is sacrosanct. This is a big word, no? Sacred or sacrosanct duty. So, example kasi, pag deed of sale, right? A deed of sale must be notarized, di ba? According to the civil code, na pag ang it involves a transfer of interest or real property, it must be in a public instrument or it must be notarized. So bago ma-transfer ang ownership, di ba, napaka-importante ng deed of sale. So yung deed of sale, para effective, it must be notarized. So for it to be notarized, the real owner and seller and the buyer must personally appear before the notary public, and that their identities must be verified, all right, so that the real property will be transferred. So just imagine kung walang notarization, and then kung walang personal appearance, bigla ka na lang, let's say you own a land, and nagulat ka na lang na yung land mo transfer sa iba, and a lawyer notarized it, di ba? So your rights will be violated. Your property will be stolen from you and will be taken away from you, and hassle yan sa'yo. Alright? So, I'm just expounding the practicality of notarization. That's why the Supreme Court had said that this is a sacrosanct duty. Alright? So, effects. So, it is entitled to full faith and credit upon its face. So, once it's notarized, it entitles the trust of the public. Because again, the notary public is entrusted by the law with a duty to ensure that the deed or that piece of paper transfers rights, protects rights, upholds rights, and that is genuinely executed. In other words, hindi siya fake, hindi siya forged. Alright? And it converts, again, in Nunga versus Veray, it converts a private document into a public document, and it's admissible in evidence without further proof of authenticity. Let's say, you present it before the court, you don't need to further prove that it is not forged, because once it's notarized, then prima facie that is presumed to be authentic. Hence, notarization should not be treated as an empty, meaningless, or routinary act. So what then should the notary do? Keyword here, it must be undertaken with utmost care to comply with the elementary formalities in the performance of their duties. The notary public must demand that the document must be signed in his presence. Okay, this must be observed. Realino versus Attorney Villamor. What is the consequence in case of omissions of notaries public? If they acted in good faith, lighter penalty. But if they acted in bad faith, in other words, knowledge, there's the knowledge that should have brought them to stop or to question such act. Then, but if they persisted in such act, they're in bad faith, then they would incur a heavier penalty. So let's look at some actual cases where there has been violations of notarization. So in Arrieta versus Llosa, for example, the signatories are already dead, and the Supreme Court said that this is a breach of professional duty and a grave misconduct on the part of the lawyer. Kasi ni-notarize niya when the seller, or I think the buyer or one of the parties are dead. So like the heirs has filed a case against the notary public. Non-attachment of the title where the notarized document is entitled affidavit of title or right of possession of third-party claimant. So yung document, let's say yung pleading or yung affidavit, ang title ng affidavit is affidavit of title. So walang title na attach. So that's a violation. If grave misconduct and first offense, suspension. If consequent offense, sorry for the typo. If consequent offense, more severe punishment. So, again, yung isa sa mga violations kung patay na. So, pag example, naging notary public ka sa uli, or you go to, if you go and see a notarized document, and then discover mo patay na pala yung party na yan at the date of notarization, then well, these cases instruct that that is a grave violation of the law of notarization. How should notarization be made? So he must exercise his duties with due regard to the provisions of the law, as in we have stated it a while ago, like it must be it must be with utmost care, right? And then with due regard of the law. If he commingles the duties of a notary public and a lawyer, I think this is with regard to litigation lawyer appearing before the court, he must be responsible for both. Hindi pwedeng irason mo lang, ay, lawyer din kasi ako, nag-appear ako sa court, and then notary public ako. No. The court said that you know what you are getting into. Pinili mo yan eh. So you should have been responsible in accepting and notarizing document. So pagkakalam ko kasi sa, let's say for example sa US, in the US hindi kailangan lawyer yung notary public, no? So pero dito sa Philippines, in our jurisdiction, one has to be a lawyer before he can be a notary public. Okay? So again, utmost care, requisite care, due diligence, regard to the law. So may isang case in Rufilo Bucana, a lawyer notarized a document that purports an agreement between the husband and the wife that they can commit adultery without opposition from either one. So nag-agree sila na hindi nila kakasuhan ng isa't isa pag ang isa ay nag-commit ng adultery. So what is that? That is a contract that is what? Against the law. Okay? That's a principle in contracts. Impliedly written in every contract, that every contract you have the freedom, right? You have the freedom to contract any stipulation and put any stipulations as long as they are not contrary to morals, public order, public policy, and the law. And this contradicts what? The RPC, the Revised Penal Code. This is an immoral contract and should not have been notarized. Judgment, 6-month suspensions against the attorney Bucana. So ninotarize niya. Kumbaga, it elevated that private agreement into public. So, walang problema pag nag-privately agree kayo. I mean, well, in a sense, wala siyang legal grounds kung sinulat lang siya sa private, right? But if it's transformed into public, then there's a problem with that, and must not perform disgraceful conduct. So, curious question. Pwede bang manotarize ng lawyer ang kanyang sariling document? Let's say siya mismo yung affiant, siya mismo yung petitioner. Can he notarize his own? The answer is no. Because the very purpose of notarization is to minimize fraud and establish a genuineness. Again, go back to the purpose. So, paano mo ma-establish yung genuineness kung ikaw mismo ang nag-certify ng sarili mo? You saw yourself signing, you saw yourself executing, and you validated your own self. Self-validation lang ba? So, the Supreme Court said in Villarin versus Ibate that it is not allowed. It would defeat the very purpose if he was one of the signatories to the instrument. Let's go to notable terms. So, notarial commission is the grant of authority to perform notarial acts and to the written evidence of authority. So, pag sinabing commission, it's like the mission of the government and the authority of the government granted to you. So parang you are an agent. You are working for the government to protect the public from falsification, and that's through notarization. And the Notarial Register is the bound book, permanently bound book with numbered pages containing a chronological record of notarial acts performed by a notary public. So it's like the inventory. It's like the diary of these acts. So, notarial act is any act that a notary public is empowered to perform under the rules. So, let's go to the most important section of a notarized document, and that is a notarial certificate. So, this can be annexed to, or this can be attached to the document in the form of, let's say, paging or putting pages, and then putting in that certification the number of pages that could be allowed, right? So this would certainly include the following. So notarial certificate is the part of a notarized document that is completed by the notary public. It bears the notary signature and official seal and states the facts attested, right? So the form of the certificate should conform to the rules. So there must be substantial compliance. So what are these? The number or the name of the notary, as exactly stated in the commission. All right? Next is the notarial commission serial number. Ina-assign kasi yan eh. And also, the jurisdiction or the province or the city or cities where the public notary public is commissioned. So if you have observed sa mga notarized documents, sometimes I see three cities. So in our case, for example, I see Don Salvador, I see Murcia, I see these municipalities. So these notaries public can only notarize documents within these areas. Okay? And then the expiration date of the commission, the office address, the roll of attorney's number, the PTR number, the place and date of issuance, and the IBP membership number. What is the consequence of executing a false notarial certificate? It shall be a ground for revocation. Okay? False notarial certificate, the certificate will be revoked, and of course, administrative sanctions to the notary public. And then, when a petitioner presents a document to be notarized, he should present what? It's called competent evidence of identity. Again, because the purpose of notarization is to establish the genuineness by witnessing the person signing before him the document and making sure that the person who signed is really the person, making sure that the signature is really made by the person who signed and who presented themselves before him. So what should be done? Competent evidence of identity. What is this? The person must present at least or either two of these or make either two of these acts. First, he must present an identification document that bears the name of an issuing agency of the government, and then it must bear the photo and the signature. So ang first kind of competent evidence of ID is presenting a card or a paper or let's say kasi mostly PVC na rin na must bear three things. Minimally, three things in the minimum. Name of the agency, photo, and signature of the petitioner. Alright? But of course, the name of the petitioner must also be present. Right? And then, meron tayong option. Ito, very rare na to. Siguro rare na rin yung mga cases na walang ID yung tao ngayon, no? But in case there is none, it should be an oath or affirmation of either of these. So, the first option is the oath or affirmation of a credible witness. So, take note of CW. CW is credible witness, meaning a person that is can be trusted, person that is of legal age. That's one. All right, not privy to the document, and he is known by both the affiant and the notary public. Okay, the individual or the notary public. So, pag kilala siya ng dalawang ito, isa lang yung credible witness na kailangan. Pero pag hindi sila kilala, okay, ang requirement is, hindi sila privy sa document at kilala nila yung affiant or individual, and they must present a competent evidence of identity or IDs to the notary public. So that's competent evidence of identity. So let's say wala kang ID. Look for one person na kilala ka at kilala din siya ng notary public. Okay? Pag wala kang kakilala na kilala ng notary public, maghanap ka ng dalawang taong kilala ka and they have IDs. And then they will swear an oath, they will make a sworn statement before the notary public that they know you and that you as a person is the same person who signed this document before the notary public. Alright? Question, in one case, yung cedula ba is a competent evidence of identity? In one case, dinictate lang ng mga affiant yung kanilang cedula number sa notary public at ninotarize ito. The answer is, the Supreme Court said no, this is not sufficient because of the reason that it can be easily obtained, plus it was only dictated by the affiants, and that is a no-no. Respondent was fooled by his own clients. He accepted this suspicious behavior without question. So yan, pag meron ng red flags, mag-question na rin, mag-caution na rin, no? Red flags na yan eh, masasaktan ka lang, ano ka lang sa huli, pag hinayaan mo yan. So wag i-tolerate, pag may mali, dapat we ourselves are we are vigilant, no, sa mga ganito na may mga signs or hints of deceit. We should not allow it. Okay, that's what the case of De La Cruz versus Zabala is teaching us. So what are the eligibility requirements of a notary public? So we can classify them into 3 categories: habitations or residence, age, and morality. So first, it must be a citizen of the Philippines. Okay, and second, must be a resident of the Philippines for at least 1 year and maintains a regular place of work or business in the city or province where the commission is to be issued. So kung saan ka nagno-notarize, dyan din dapat yung iyong office and dyan din dapat yung permit or commission. Okay? So residence and citizenship. In political law, there's a difference between the two, no? And number 3, may or must be over 21 years of age. Number 4, must be a member of the Philippine Bar in good standing, meaning he has been cleared by the OBC, Supreme Court, and IBP. In IBP, that also means payment of annual dues, updated dues. Number 5, must not have been convicted of any crime involving moral turpitude. So these are the basic requirements of a notary public. So where and how long can a person commissioned as notary public perform notarial acts? So kailan and hanggang kailan? Saan? So sa saan? Within the jurisdiction limits, no? Territorial jurisdiction of the commissioning court, and 2 years, starting January 1 of the year in which the commissioning is made unless revoked by the rules. So, within the territory and 2 years. So, dito na tayo sa medyo body ng ating content. Ano ba yung powers of the notary public? So, the answer based on the rules or the administrative matter that was promulgated by the Supreme Court. These are acknowledgments. Okay, they are allowed to perform acknowledgments, oaths and affirmations, jurats, signature witnessing, copy certification, and any other act authorized by the rules, and also to certify the affixing of a signature by thumbmark or other mark on a document. So, medyo sineparate tong thumbmark affixation, no? Kasi may mga tao, syempre, na hindi sila makasulat, so they only have to put their thumbmark, or probably those that are bedridden, so hindi sila makapirma. So, a notary public must be there to certify the authenticity of such document. So, isa-isahin natin, in a while, ang mga powers na ito. Okay? So, all in all, these acts or these powers of a notary public can be summed up into a power to render a document as authentic and genuine. Kanina pa natin inulit-ulit, no? Diba? From the word nota, to note that it is genuine. Okay? So, nota, notarus, genuine yan. Okay? So, let's go first to acknowledgement. What is acknowledgement? It is an act in which an individual on a single occasion, so tandaan na, pag sinabing acknowledgement, hindi yan act in the first place by the notary public alone. But first, there must be an act on the part of an individual. Okay? Or sa terms natin kanina, petitioner. Di ba? There must be an act of an individual on a single occasion. So tandaan natin na it's only on one occasion. So pag one acknowledgement, pag one act, one occasion, that's one acknowledgement. So what does he do? Or what did he do? He appears in person, tandaan natin yung word na in person, before the notary public and presents an integrally complete instrument or document. Okay? So yung essence ng act na ito is the presentation of the complete document. From the word acknowledgement, what does he acknowledge? What does the notary public acknowledge? That is the integrally complete document. Yung dalawang ito, yung B and C, which is the presentation of an ID or competent evidence of an identity, and the the representation that it's voluntarily fixed, these are also like the additional signification of this act. So, acknowledgement of what? Acknowledge that the document is integrally complete and the signature therein was voluntarily affixed. Alright, so that's acknowledgement. Again, basically, document is complete and the voluntariness of the signature. Now, let's go to oaths and affirmation. Ano naman ba ito? It is an act pa rin of an individual on a single occasion where he personally presents a complete document. So, ganun pa rin that the similarities is they present similarly or an integrally complete document, personally identified, but avows to the whole truth of the document. So, kanina yung acknowledgement is that it was voluntarily signed, the signature was voluntarily affixed, but sa oath and affirmation that he avows to the truth of the document. Kasi oath Oath means avowals, vows. Affirmation means to affirm the truth of the document. Okay, so voluntariness, acknowledgement. Oaths and affirmation is avows to the whole truth of the document. So, ito, chinek ko ulit sa Google yung pronunciation niya, and that's Jurat. Okay, Jurat. What is Jurat? It is a clause, no? At the foot of the affidavit showing when, where, and before whom the actual oath was sworn to or affirmation was made and the signature was made. So, dalawa, the oath and the signature. So, parang it's a combination of signature witnessing and oath and affirmation. So, again, the oath and affirmation is that the document was sworn to, and then the signature witnessing is that it is signed before the notary public. So, this is the example of a jurat, okay? Very familiar kung kayo ay nagnotaryo or nagpapanotaryo. Subscribed and sworn to me, and subscribed and sworn to before me this day of month, year, at city or municipality, province, affiant exhibiting his or her competent evidence of identity by way of type of identification with ID number and date of issue, issued at place of issue. So again, the components or the elements thereof can be seen here. Subscribed, okay, that it was signed before the presence of the notary public, and it has been sworn or oath and affirmed, okay, oath and affirmation. Okay, so the year, date, the place is indicated here. Alright, so again, it came from the word jurat, from the word juratus, which means sworn. And that means that it refers to an act where an individual in a single occasion appears, okay, before the notary public and present a valid ID or an instrument and present the integrally complete document, is personally known to the notary public or is identified through competent evidence of identity. So dito na, the last two are the crucial ones. It is signed, okay? The document is signed in the presence of the notary, subscribed, okay? And number 4, that he takes an oath or affirmation. Okay? He avows to the whole truth of the document before the notary as to such document or instrument. So again, signed and sworn. So ano yung sinumpaan niya? Na totoo ang contents ng kanyang document or instrument. Alright, so that's jurat. So more of the jurat, it is a part of an affidavit where the notary public certifies that the instrument was signed and sworn to before him. Okay, again, it is a part, it is annexed. Okay, it certifies that the instrument was sworn and subscribed. So always remember these two S, SS. Jurat equal to SS. Sworn and subscribed. So again, subscribed means signed, to write underneath, to sign at the end of the document, while swear or sworn means to put an oath to the truth of the pleading. Okay, a jurat is not part of the pleading but only evidences that the document was properly made. So tandaan na, it's not part of the pleading but only as to the certification that it is truthful and signed. A jurat is not the same as acknowledgment. So what again is acknowledgment? That certifies that the document was voluntarily signed, while jurat certifies that it was sworn and subscribed to before the notary public. Okay? So can a defective jurat invalidate a marriage? So this is one case law. No. The answer is no. Why? Because the lack of document and page number in a jurat is not one of the grounds under the law that would invalidate a marriage. Sa case kasi na ito, walang page and document number sa jurat. Okay? And also, one reason is that, so we just discussed in the previous slide that it is not part of the document. So in this case, it's not part of the marriage license. What renders a marriage null and void is marriage without a marriage license. So that's people versus imutan. Where are jurats usually seen? This is usually seen in affidavits because there's a need to certify what? To the statement of the affiant or to the truthfulness. So pag nag-testify siya, okay, affidavit, judicial affidavit, for example. So there's a jurat there so that the affiant, okay, or the principal will have to certify that what he said or what he wrote, what he stated was true to the best of his knowledge. Jurat is usually needed for what? Unilateral declarations. Okay, unilateral. So just one person declaring statements. So affidavits are normally done ex parte without the initiative of another party. That's only one party initiates affidavits. So that's jurat. Now let's go to another power of a notary public. So signature witnessing naman. This is the fourth power of a notary public. Ano naman ito? This refers to a notarial act in which an individual on a single occasion. So pause muna. Kanina, yung first three, those are an act of an individual in a single occasion. So ito naman, this is a notarial act because who witnesses the signature making? That's the notary public. So it is a notarial act first and foremost. So what does she do? So, well, appearance and competent evidence of identity, andyan yan. So ito, i-highlight ko with yellow. Okay, first. So that's, kumbaga, this is the common denominator sa kanilang apat so far, right? But the difference is that he signs the document in the presence of the notary public. So na-witness ito ng notary public and he certifies that he has witnessed the signing of the document. So again, parang nag-redundant tayo kasi na yung jurat nalagay natin sa gitna. But if we put it this way, yung number 2 yung signature witnessing, so signing, subscribing, and then yung oath of affirmation is sworn, okay, or the affirmation, or you attest to the truthfulness of the contents of the document. If you combine these two, that's jurat. Okay, so it can be oath plus signature equals jurat. So that's a formula, pas madali nating matandaan. Okay, so that's signature witnessing. So far wala pa naman ako personally, mas always ko nakikita yung jurats. Okay, kaysa sa signature witnessing and oath and affirmation. Siguro acknowledgement, I have seen it so far. Yung it was voluntarily affixed, the signature was voluntarily affixed. But signature witnessing, maybe it's a rarer kind of activity, no? Then because jurat already includes that. Okay, pag na-note na may jurat na, right? So yeah, so let's go to the next power, which is copy certification. So what is copy certification? It refers to an act in which a notary public, so this one halos apat siya at magkaiba, medyo magkaiba na kaysa sa previous 4. So a notary public is what? Is presented with a document that is neither a vital record, public record, nor publicly recordable. So it's not a public record, which means it's not a court decision, it's not a birth certificate. It's a that's private. Okay? He copies or supervises the copying of the document, compares the document with the copy, and determines that the copy is accurate and complete. So I think the keyword here, if there's a keyword of all keywords, it's the accuracy and completeness of the copy. So accuracy and completeness, A and C. So what does it certifies? That the copy that you are holding right now, for example, ikaw yung let's say respondent, and there's a copy certification, or you are the government agency, you received a copy of, let's say, a letter. If there's a copy certification by the notary public, you can rely that that copy is accurate and complete, okay, because it has been notarized. So you can now put your faith on that document because you have the assurance from the notary public. Okay, that's copy certification. So that the last one is any other act authorized by the rules, which I do not have as of the moment. I only have these 5 based on the 2004 rules on notarial practice. So let's compare and distinguish these 5 powers. So the first 4, these are acts of the individual, while the copy certification is the act of the notary public. Actually, signature witnessing, as we have said a while ago, can also be primarily the act of the notary public. No? So medyo tandaan lang, no? The correction here. It's an act of the notary public whereby he witnesses the signing of the document in his presence. Now, let's go to the distinction. So acknowledgement, again, just to repeat, that the signature was voluntarily fixed. You acknowledge. Signature witnessing, that it is signed in the presence of the notary public. Sa oath of affirmation, avows to the whole truth. So, tandaan nyo lang, letter O, so letter O din. And then letter A, so parang you jumble the A to, you put the A to the first letter and then O to the next syllable. So oath means to avow to the truth of the whole truth of the document. Combine these two, so tinabi ko sila because subscribed and sworn to before me this day. We get the Jurat. So Jurat means that the individual, it is an act of the individual wherein he signs and avows to the whole truth of the document. So again, it's embodied by the word subscribed and sworn to before me. Where, when, here in this place, at this date, okay, before me, and then the seal and the signature of the notary public. Okay, copy certification. This is very unique because it is an act of the notary public alone, wherein he witnesses the copying and he compares the copy and he certifies the accuracy and completeness of that copy, and that proves that it is a genuine, faithful copy of the original. Okay, so usual usage for acknowledgments, it's usually observed in bilateral obligations. Okay, what is it? Deed of sale. Okay, deed of mortgage. So usually that's acknowledgement because you as buyer and seller, for example, you acknowledge that the buyer voluntarily sold and the seller voluntarily sold and the buyer voluntarily bought the item or the property. Same as with deed of mortgage. So you voluntarily entered into that contract. Why? Because again, consent is a crucial element, essential element of a contract. Again, going back to our obligations and contract, the elements of a contract, one of the most important one is consent. So without consent, there will be no valid contract. And how to prove and how to establish that there is a valid consent? Through acknowledgement. Na in-establish yan ng notary public that the signature was voluntarily fixed, not by duress, not by vices of consent, not with vices of consent such as fraud, coercion, violence, or force. That's the power of acknowledgement. And now with acknowledgement, a property, a deed of sale can now be validly accepted as an evidence, and then you submit it. So if it's a deed of sale, you can now submit it before the ROD or the BIR, and now the ROD can now transfer the name of that property to the buyer. So ganyan ka powerful, no? So dinidescribe ko lang yung, I'm just visualizing how powerful acknowledgement is. It can transfer properties, it can transfer corporations, it can transfer lands, it can transfer houses. That's why, again, going back to the teaching of the Supreme Court, it is a sacrosanct duty. Okay, the notarization, the act of notarization. However, on Jurat, as you have said, this is usually seen and observed in unilateral declarations, such as what? Affidavits, because they are done ex parte. So you signed it and you swear to the truth of that document. So hindi naman kailangan na voluntarily affixed, kasi nga ikaw na yung nag-state niyan eh. So that's so acknowledgement talaga para sa bilateral, no? While sa unilateral, it's Jurat. So ano yung mga bawal sa mga notary public? Let's start. As to the place, bawal silang where should a notary public perform notarial acts? Only in their place of work, such as the law firm. They shall not perform notarial acts outside their regular place of work. Dapat doon sa kanilang office where the seal is, okay? And that's where their secretaries are, for example, and their paralegals are. Except at the request of the parties and at the following site located pa rin dapat within their territorial jurisdiction. Okay? Sites ito kasi iba kasi yung territory sa sites. So it can be within the same city, but these sites can be these. So number 1, public places. Basahin nyo na lang yung expansion yan. Public areas of private places such as like function halls of hotels. Okay? Hospitals and other places where there's confinement. So that's treatment, places of treatment. Hospitals, emergency rooms, and places of detention such as, bilibid or jails. So these are places where the notary public can only perform the notarial act. So may minsan may reklamo, but hindi na lang dito ipanotaryo? No, kasi bawal as per the law, it must be notarized in the place of business of the notary public generally. Okay, as to persons naman, paano naman? Sino or kailan dapat siya i-perform? The signatory to the instrument is not in the notary's presence. So pag wala yung principal or ang petitioner before the presence of the notary, so hindi yan dapat manotarize at the time of the notarization. Kasi kailangan nga, like sa Jurat, that one evidence of authenticity is that the notary public witnesses the signature, the signing of the document. And it's not personally known to the notary public or not identified by competent evidence of identity. So dapat also ma-satisfy yan. Ma-identify siya ng notary public. Either kilala siya or nakapresent ng ID, no? Or yung oath of affirmation as we have stated in the previous slides. And then another is if he is a party to the instrument that is to be notarized. So bawal yan, no? Again, we have discussed that. Will receive a fee or other consideration because of such notarial act except as provided by law. So, of course, may notarial fee tayo, and usually like sa affidavit of loss, mas mura siya. For example, kaysa sa mga deed of sale, okay, or deed of sale with extrajudicial settlement, mas mahal yan, yung mga yan. Kasi nga, there's more things to check and more accountability and liability as to the part of the notary public, kasi nga mas malaki yung conveyance, no? Sa mga documents na yan, mas malaki yung stake, so mas mahal. But the limit is as provided by law. Usually sa mga IBP, may nirelease yung IBP na mga tables or mga schedules kung magkano ang like minimum. I think that the minimum fees. So usually pag bagong lawyer, ito yung pinapakita ng bagong lawyer sa mga nagpapanotaryo para for protection din ng notary public, no, na makasingil siya ng kanyang fee. And last is a spouse, common law partner, ancestor, descendant, or relative by affinity or consanguinity of the principal within the fourth civil degree. So pag relative ka as a notary public ng principal, bawal. Pag ancestor ka, pag descendant ka, pag common law partner, pag nagli-live-in kayo, bawal. Pag spouse ka, bawal. Well, again, because the purpose is to certify the genuineness. So, syempre, pag pamilya kayo, you can, it will encourage, supporting false, it's a temptation. So, the law has established these rules. So, since bawal yung person na hindi personally mag-appear before the notary public, plus walang competent evidence of identity, it's worth mentioning kung ano ito. So, hindi ko nababasahin lahat, but the basic requirements is that he must present a valid ID. And when we say valid ID, it must bear the name of the government agency, the picture, and the signature, plus the oath and affirmation of the following, of the either of these two below. Okay, so, pwede ba mag-refuse yung notary public? So, when or what instances? So, first, if may reason siya na mag-believe na yung transaction is unlawful or immoral, such as, for example, the consideration or the object is prohibited. Okay, so he has a valid reason. He can validly refuse to notarize. And then when the signatory shows a demeanor that renders the notary a doubt as to the signatory's knowledge of the consequences of the transaction. So let's say may na-detect siyang incompetency on the part of the signatory or the principal. So again, the purpose is to certify the genuineness. So pag hindi niya alam, pag hindi siya competent sa kanyang sinumpaan, let's say may vices of consent, then he can refuse. The signatory is not acting of his own free will based on the notary's judgment. Again, vitiation of consent or vices of consent, vitiation, coercion. So, notarization can be declined by the notary public. Let's go to notarial fees. How may a notary charge? So, as much as the Supreme Court may prescribe unless he waives the fee in whole or in part. Only those expressly allowed by the rules must issue receipt and keep a journal of notarial fees. Post the schedule of notarial fees in a conspicuous place. When can a notary charge travel fee and expenses? So if it is requested prior to the travel by the principal or by the petitioner, it must be agreed upon. And that the notarial act has been completed, if not completed, provided that the failure happened beyond the notary's control. So again, it must be agreed and the act must be completed so that the fees can be charged by the notary public. So now, after the notarial act has been done, may dapat pang gawin yung notary public, and that is the recording of notarial register entries. So, what is the form? Ano yung manner na i-keep or in a manner that is to be observed by the notarial public? So it must be permanently bound book. It is a chronological official register of notarial acts. In the first page, the Solicitor General shall certify the number of pages of which the book consists. So, kumbaga kung sa record book pa ba, kung sa security guard may logbook yung mga notarial register, or sa mga in any secretary there must be a chronological register of the act. So dapat may numbering. The reason why, so that may kumbaga kung sa mga solicitation letter may control number. And then sa first page, just like the BIR logbook, dapat tatakan din ng BIR. So dito may tatak ng Solgen to certify the number of pages of which the book consists. So it's like a safeguard, a protection mechanism. So ilang pages to, and then walang dapat skip yung numbers. If there's let's say a void act, then it must be indicated so. And the notary public shall only keep one active notarial register at any given time. So these are the safeguards of the law, so that the notarial register should also act as an instrument to guard from any any deceitful practices or fraudulent activities in relation to notary acts of notarization. So who furnishes the Notarial Register? It's the Solicitor General upon request and payment of the cost thereof. Now, let's go now sa pagkeep. What is the manner of keeping the notarial acts? So first, the entry and page number. Okay? So, lagay dapat sa, di ba, pagtingin mo sa certificate, notarial certificate, meron diyang page number, book number, usually, no? Entry number. So, entry and page number are important. So, let's say sa first page kasi yung tatak. So, let's say page 2. So, una-una page 2. So, entry number 1, page number 2. That's usually, ideally, the first notarial act. And then book 1. So, pag it's your first time to become a notarial register, so it could be entry number 1, page number 1, or page number 2, and then book number 1. Okay? The date and time of day of the notarial act. Of course, the type of notarial act. Okay, that could be Jurat, that could be acknowledgement, that could be signature signing, etc. As what we have discussed in the previous slides. The title or description of instrument, document, or proceeding. The name and address of each principal. The competent evidence of identity as defined by these rules if the signatory is not personally known to the notary. So, well, the rule says or, but in practice, talagang dapat i-present yung ID, no? The name and address of each credible witness swearing to or affirming the person's identity. In this case, pag walang ID. Number 8, the fee charged for the notarial act. Number 9, the address where the notarization was made, if not done in the regular place of business. Okay? So, pag ito yung mga special circumstances. So, what if the instrument is a contract? So, the notary shall keep an original copy of the contract as part of his records. The duplicate original copy for the clerk of court. So, pinapasa sa clerk of court yung mga contracts. Again, because every contract may copy yung clerk para sa tinatawag nating someday if this has been raised before as an issue, then the clerk of court has copies and that he can certify to the genuineness of the contract as well. In the records, he shall keep a brief description of its substance and give a consecutive number which begins at number 1 in each calendar year. Okay? So, that's how contracts, no? So, this is a safeguard. So, lahat pala ng kontrata, may kopya yung clerk of court ng bawat jurisdiction. So, that's a big lesson to protect, of course, the rights of parties na involved sa contract na yan. So, how shall each document be numbered? The number should correspond to the one in the register. So, again, yung register, merong number and it must correspond sa document. Okay, so document number, page number, book number, and series number. Okay, so yan, this is the ideal one, and then the stamp should be behind, no, as watermark at the numbering. No blank line shall be left between the entries. So again, entry number would consist, no, sa register may entry number and page number, pero sa document may document number, may page number, may book number, and series, and that is the year. So again, we could say that the document number 1 will always start with the first document of any given year. So pag 2022, may document number 1 na naman uli yan, page number 2 for example, no, or page number 1, as the case may be. So, what if may protests? If in case of protest of any draft, bill of exchange, or promissory note, the notary public shall make a full and true record of all proceedings in relation thereto. So, yan din. Pag may protests, dapat may proof din. That's why the notary public can also certify as to the truthfulness as to the existence of such documents. And what shall be done regularly by the notary? So, weekly, certify the number of instruments executed, sworn to, or protested before him. For monthly, within 10 days of the following month, the copy of each month's entries and duplicate original copies shall be forwarded to the clerk of court. So let's go now to the inspection, copying, and disposal of a notarial register. So as to the inspection, what if a person wants to inspect an entry in a notarial register? So pwede palang i-inspect yung mga entries dyan. Okay? Because again, it's a public record. Well, in a sense, it's a public record because it can be viewed, no? But the person's identity first must be personally known to the public, to the notary public, or he must prove it through competent evidence. And he must do it during business hours and in the presence of the notary public. The person specifies the type of instrument, the name of the principal, and the instrument's mounted year. The person affixes a signature. The person is shown only the entry specified by him. So again, this is to certify na yung document na yun is notarized. Who else can inspect the notarial register? It's the investigation officer, maybe the police, or by virtue of a court order. When can a notary deny access to the entry? When he has reasonable ground to believe that there is criminal intent or wrongful motive in requesting information from the notarial register. Copying. Pwedeng mo makopya. What is the process? First, he must pay legal fees, and the notary shall supply a certified true copy of the notarial record or any part thereof. That's the reason why sinabi natin kanina that notarization converts a private document to a public document kasi pwede siyang makopya by anyone as long as meron siyang legitimate lawful motive. Okay? So what if nasira or na damage yung notarial register? So police muna. Go to the police report. So this is commonly called blatter, no, in case of theft or vandalism, or let's say pag nawala, well, affidavit of loss. And then the notarial register or the notary public shall notify the executive judge. Again, you go back to executive judge pag may loss, no, or theft or vandalism by means and provide a copy of the police report, ask for receipt, and provide registered mail. Because this will also protect the notary public in case that will be used by any ill-motivated person to notarize other documents. Also, what shall be done upon the expiration, revocation, or death of the notary public? The register and record shall be delivered immediately to the hindi to notarial judge, to the executive judge. So again, since every notary public is under the supervision of the judiciary, then it's the executive judge who has the obligation to have these in possession in case of the expiration, death, or revocation. Okay? So, di ba kanina yung na-learn natin that notarization or a notarial certificate is a seal, no? It signifies it's a physical mark of a spiritual reality. So, let's go now to the seal. What should the seal look like? Okay, the seal maker should be made of metal, circular in shape, 2 inches in diameter. So mabigat yan. The image should be clear, legible, permanent, and photographically reproducible mark. Have the name of the city or province and the word Philippines. So city and the province and the Philippines. That would entail or that will show jurisdiction. His name on the margin and the roll of attorney's number. Notary public across the center. Okay, so name, roll number, jurisdiction, and the roll number, and the word notary public. How shall a notarial signature notarize a paper document? So the notary public should sign by hand on the notarial certificate, and of course the seal. He should not use facsimile. Okay, this is not use facsimile stamp or printing device. He should only sign when the notarial act is performed. When should the seal be impressed? Only at the time the notarial act is performed, and it should be clearly impressed on every page of the instrument notarized. On every page, ha? Tandaan. This might be asked. Kasi may iba na baka last page lang, no? But it must be every page. That signifies that every page has been read, has been certified as authentic and genuine. How should the seal be preserved? It should only be accessible by the notary public, and if lost, it must be reported. Same process kanina, have the police report, the blatter report, and notify the executive judge in writing as the case may be, no, in the case of crime. What shall be done after the death or resignation of the notary public or revocation of the license? The seal shall be surrendered to the executive judge and destroyed in public during office hours. So, yeah, because this will prevent the malicious usage of that seal of the notary public that has died or has resigned. Failure to do so shall constitute contempt of court. So, this must be surrendered. What are the requirements for a vendor or manufacturer before selling the product? So, yan yung mga requirements. So, yung nagmamanufacture ng seal, dapat may application fee, dapat may license, no? Shall be investigated, shall be authorized for 4 years, and must have a certified copy of the Notarial Commission and certificate of authorization to purchase a notarial seal. So, yung buyer, meron dapat commission muna from the executive judge. Okay? What shall evidence the authenticity of the notarial seal and signature of the notary public? So kanina dapat may commission siya, no? So once ma-commission siya, he can order now the seal. But what shall evidence the authenticity of the notarial seal? So bago ka magkaroon ng seal, again, what should you have as a notary public? The commission, the certificate of authority from the executive judge. So, not just the seal, but the certificate. Kasi pwedeng na nakaw lang. No? So again, going back to the case na may pwedeng nakawin yung seal, hanapan ng certificate or authorization from the executive judge. Pag wala yun, wala. That's a fake notary public. What are the grounds for revocation of notarial commission? So hindi ko na babasahin one by one, but some of the notable ones are hindi pag-keep ng Notarial Register at failure to affix acknowledgments, failure to send copies, no? Fake reports or failure to make reports, failure to require the presence of a principal. No? Ito yung karamihan sa mga case usually na hindi ni-require yung presence ng principal, and that would constitute the notarization of a questionable document. Kasi hindi mo alam kung talagang siya talaga nag-execute ng deed of sale, for example, or nag-transfer, nag-donate. So that's the nuance, no? So pwede bang ireklamo ang notary public? Yes. So what should someone do if he has a complaint against the notary public? So, he must file a what? A verified complaint. So, it's a complaint, it's a pleading that sets forth your claims. And again, verification is a statement under oath wherein you certify to what? 3 elements: truthfulness of your statements. Number 2, that it is made in good faith and it is supported by evidence. The judge may file a case motu proprio, or the executive judge, no? So, for example, yung mga merong cases na basta-basta na lang sila nagnonotaryo na walang presence of the principal, or may mga questionable practices, the executive judge himself can file a complaint. And then the notary public shall file a verified answer to the complaint. So verified answer, it's also a pleading that sets forth his defenses. Okay, that shows the practice or the exercise of due process, no? The right to be heard. If allegations are not proven, dismiss the case. If allegations are established, appropriate administrative sanctions. And if answer is not satisfactory, conduct a summary hearing. Okay, so proven, dismiss. If established, then administrative sanctions such as revocation of the commission and the license and the seal. And if answer is not satisfactory, then conduct a hearing, summary hearing. Quick lang, no? So, talking of the executive judge, here are the duties of the executive judge. Supervision. So, lahat ng notary public under the eyes of the executive judge. Motu proprio, initiate administrative proceedings. So, kanina, pag may questionable practices, he may file a verified complaint. Order the clerk of court for the posting of the names of notaries public who were sanctions or who were revoked, so that the public may know. Shall fulfill the obligations under the rules in case notary did not fulfill the obligations. Shall cause the prosecution of a person. Ito naman yung private or non-lawyer, for example, or a lawyer who impersonates a notary public, who knowingly destroys the seal, register, official records, or knowingly coerces a notary public to commit official misconduct. Okay, that this can even entail criminal case now, and shall submit semestral reports to the Supreme Court on discipline and prosecution of notaries public. Right? So that's the duty. These are the duties of the executive judge. So, thank you very much for watching and appreciate your time. Please don't forget to subscribe for more videos.